Well, it's not really untested. There are quite a few English cases already on it, and there are a number of South African cases on Facebook. And the other point is that it's an application of existing laws that have been around for hundreds of years. So there's nothing really new about it. It's just a new way of disseminating information on a new platform. Nothing really major or substantially different to, for example, when broadcasts emerged relative to print. Courts had to grapple with that new technology. How does it apply? Same thing's happening, I think, in the online space. Well, already the Facebook cases that we've seen here have been ones where the courts have said that you are liable for what you publish online. There's no Wild West immunity here. You are just as responsible as if you had published it in the newspaper or on television or in a radio broadcast. And so you have to be very careful about how you navigate your way around all the legal pitfalls when you publish online. Well, we already do a lot of social media cases within our existing media law team, but it's certainly a growing area of our practice. I mean, there's very few defamation cases that you now get that don't have an online angle, whether it's a comment from a user or publication of the online article or anything to that effect. Well, it's both civil and criminal, depending on the area of law concerned. So if you're talking, for example, defamation, that's both a civil and a criminal angle, just like in the offline space. I would expect us to see quite a few cases dealing with online comments. I think that's going to be the next test case. Do you moderate before you publish? Do you not? Do you rely on automatic filtering software only? Do you take identities of your users, or can they be anonymous? These are the issues I think that the courts will confront rapidly. Very little, actually, because they're based in the States. And in the States, there is absolute immunity for content under Section 230 of the Communications Decency Act there, which gives, except for some intellectual property related issues, mainly they have basic kind of immunity even after publication and even after notification of unlawful content. So it always is very, very difficult to take on a Google, Yahoo, YouTube, etc. Because they benefit from this immunity, and there's no incentive for them necessarily to comply with South African law. So you have to rely on their policies, and we've had a number of cases against Twitter, Facebook, Google, in the context of acting for clients. They've been pretty reasonable on the level of these are our terms of use, and if there's non-compliance, we'll take action. But not on the level of saying, you are now liable, Google or whoever, for what you publish. I mean, they'll resist that because they've got that immunity in US law. Well, I think that if there's not someone who they can sue who's got deep pockets, the courts will tend to say to the host of the content that you may well be liable. And in Europe, there is a developing jurisprudence. One of the cases has said that if you know that the article that you've put out is risky, you should expect that commentators will make defamatory comments. So you can't say, well, I didn't know about it until you now told me about it. You've actually got to monitor before. That's the implication of one of the judgments. So it's a fascinating area and one we'll see developing.